my God! Ah! Hello, my fam. It is Perez, the queen of all media, the original influencer, journalist, podcaster, Swiftie, and your number one source for everything It Ends With Us saga. We are less than a month until Taylor Swift releases her new album, The Life of a Showgirl, and shortly after that, she's gonna be deposed in the saga. As many of you know, the A-list wannabe and the real A-lister were really good friends. In fact, the toothless ballbuster even named Taylor Swift godmother of her children with the former fiancé of Alanis Morissette. But unfortunately, or fortunately, Ryan Reynolds' second wife is no longer close to Taylor Swift. But Taylor Swift is close to a lot of relevant information that can help Justin Baldoni. That's why she was subpoenaed earlier this year. That subpoena was withdrawn, but we just found out in a new filing that Taylor will be deposed. She has agreed to it. Her deposition is going to happen at the end of October. I've got all the details, but first, we only found out about this because the basement manager just sent a new filing to Judge Lyman asking for more time. Deja vu. Ethically challenged Ezra told the court, in accordance with sections 1C, 1D, and 3A of Your Honor's individual practices in civil cases, and following meet and confer with counsel for all parties in this action, Plaintiff Blake Lively respectfully moves to modify the court's case management plan and scheduling orders to extend the current deposition deadline from September 30th, 2025 to October 10th, 2025, to afford Miss Lively sufficient time to prepare for and take the depositions of defendants Steve Sarowitz, Jamie Heath, and Justin Baldoni in light of recent voluminous and delayed productions of the Wayfarer defendants, of which Miss Lively previously apprised the court. As detailed further below, the proposed extension will not affect any other existing dates or deadlines, including for trial or the filing of the joint pretrial order. Now, this is important because the deadline that Team Kaka is giving is October 10th. But Taylor Swift cannot be deposed until after October 10th. We'll get to that, but first let's finish with this latest filing from Betty Buzzkill's attorney. In accordance with Section 1D of Your Honor's individual practices in civil cases, Ms. Lively states the following. Under the current case plan, as modified on July 15th, the deadline for the completion of depositions is September 30th, 2025. On July 3rd, 2025, Miss Lively and the Jones parties previously moved to amend the case plan to extend the close of fact discovery by 6 weeks to run concurrently with expert discovery, which was partially opposed by the Wayfarer defendants. The court partially granted this request in an order dated July 15th. On September 8th, the parties jointly moved to amend the case plan to extend the deadline for the completion of expert discovery by 30 days, which this court so ordered. On September 10th, 2025, counsel for the parties met and conferred regarding Miss Lively's requested extension and have reached an impasse. Counsel for plaintiff and the Jones parties consented to this request. Counsel for the Wayfarer defendants refused to consent to this modest extension, instead insisting that they will only agree to an extension of the current deposition deadline if it is granted for 30 days for all discovery, including both party and third-party depositions. Counsel for Jed Wallace and Street Relations have not stated a position. So what's the problem? The Woody Allen apologist requested an extension of a couple of weeks, and now they're willing to give them that if they just extend it a little bit longer. That seems sensible to me. You? Ezra continues. The party's next scheduled appearance before the court is a post-discovery status conference scheduled for October 21st, 2025 at 10 a.m. Good cause exists for Miss Lively's request for a modest extension of the current deposition deadline. Under this court's prior orders, the party's deadline to substantially complete document productions was July 1st, 2025, following repeated efforts to cure deficiencies. It's their fault. Following repeated efforts to cure deficiencies in the Wayfarer defendants' productions, Miss Lively filed an omnibus motion to compel on August 4th. On August 27th, 2025, this court granted in part Miss Lively's omnibus motion. As part of the discovery order, the Wayfarer defendants were ordered to produce by September 2nd, 2025, documents identified as categories 1 through 9 in the order and all other discovery, including signal communications, by September 8th. We know that didn't happen. On September 8th, the Wayfarer defendants produced more than 6,700 they're changing their tune now. This is something. On September 8th, the Wayfarer defendants produced more than 6,700 documents, or 80,000 pages. That's not what they referred to it as earlier this week. They said over 80,000 documents, right? Or am I remembering incorrectly? Now they're saying 6,700 documents or 80,000 pages. This voluminous production required more than a day for Miss Lively to process for review that has only begun in earnest today. Based on our initial review, this production only includes 62 signal communications, which are duplicate copies of the same communications from the Tag, Nathan, and Abel productions, and thus appear to represent only a handful of likely signal communications. Also on September 8th, and without first conferring with undersigned counsel, the Wayfarer defendants moved for a 1-week extension to produce what would appear to be a substantial collection of signal communications from Melissa Nathan, Steve Sarowitz, Brian Friedman, and Summer Benson. Summer Benson is a lawyer, which this court denied for failure to demonstrate good cause. As of this letter, the Wayfarer defendants have still not produced the signal communications ordered by the court. You see, this is why you read everything, because you never know what juicy tidbits are going to be included in that. Oops. Instead, ethically challenged, Ezra continues, the Wayfarer defendants are openly defying this court's prior order and have brazenly insisted that they will not produce further signal communications until at least September 15th, the same day that defendant Sarowitz was scheduled to be deposed. It remains unclear whether even that belated production will be complete. Accordingly, Miss Lively informed the Wayfarer defendants on September 10th, 2025, that the deposition... I did not know this either. I love this. I am too invested, y'all. Accordingly, Miss Lively informed the Wayfarer defendants on September 10th, 2025, that the depositions of Mr. Sarowitz, Mr. Heath, and Mr. Baldoni, which had been scheduled after painstaking scheduling negotiations for September 15th, Sarowitz, September 18th through the 19th, Heath, and September 21st through the 22nd, Baldoni, would need to be rescheduled to permit sufficient time to review the Wayfarer defendants' unauthorized and belated productions. In light of the above, Miss Lively respectfully submits that good cause exists for the deposition deadline to be extended briefly by 10 days to afford Miss Lively sufficient time to prepare for and take the depositions of defendants Sarowitz, Baldoni, and Heath. Miss Lively also requests that this court instruct the Wayfarer defendants to make defendants Sarowitz, Baldoni, and Heath available for depositions during this modest extension. All right, I'm Team Truth. So far, this all makes sense to me, and I think the judge should grant this. However, unlike the 30-day delay sought by the Wayfarer defendants, Miss Lively's proposed extension will not otherwise impact any other deadline, including the expert schedule just ordered by this court or the trial date previously set by this court. To the extent the Wayfarer defendants pursue, as is anticipated, their baseless demand to extend the entire discovery schedule by 30 days, Miss Lively respectfully requests that it should be denied. A 30-day extension would necessarily impact the current deadlines under the case plan, including the expert discovery schedule, which was just amended, motions for summary judgment, and the current trial date. Put simply, the Wayfarer defendants are entirely responsible for the scheduling conflicts that the parties now face and should not be permitted to leverage these issues as a means to extend discovery for their benefit. So that's the real tea. So let us hear from the Wayfarer parties. And they have a lot to say because they submitted 2 new filings. First, defendants Wayfarer Studios LLC, It Ends With Us Movie LLC, Justin Baldoni, Steve Sarowitz, Jamie Heath, The Agency Group, Melissa Nathan and Jennifer Abel, and Jed Wallace and Street Relations respectfully move the court to enter a protective order directing non-parties Brianna Butler-Coslow and Catherine Case, both of whom are previous and one is still a current employee of Melissa Nathan, the crisis PR expert. The Wayfarer parties are moving the court for a protective order directing these two not to produce certain documents the court previously ordered them to produce in its September 9th, 2025 order on the grounds that those documents are protected from disclosure by the attorney-client privilege. When it issued its order, the court may not have been aware that the Wallace parties, Jed Wallace and Street Relations, have been represented by counsel for the Wayfarer parties in this matter since December 2024. Defendants now request the court modify its prior order or enter a protective order as described below. Both sides are fighting tooth and nail over everything. Not her side, that side. On September 9th, 2025, the court entered an order granting in part and denying in part Blake Lively's motion to compel Koslow and Case to produce documents withheld on privilege grounds. The order holds in part that Ms. Case and Ms. Koslow, agents for defendant the agency group, waived the attorney-client privilege by including Mr. Wallace on certain communication with counsel for the Wayfarer parties. However, Mr. Wallace was jointly represented by Liner, Friedman, Titleman, and Cooley, counsel for the Wayfarer parties, and thus disclosure of privileged communications to Wallace did not and could not have waived the attorney-client privilege. A December 24th, 2024 engagement letter between LFTC, the law firm, and Mr. Wallace and Street Relations Incorporated, Bates stamped, was produced to Ms. Lively on September 8th, 2025. The letter, which is being concurrently filed as Exhibit A, clearly identifies Mr. Wallace and his company, Street Relations, as clients of the firm in connection with their dispute with Blake Lively and related parties. Although Wallace is jointly represented by separate counsel, he remains an LFTC client. This is first time I'm hearing this. Right? I always thought Charles Babcock, right? The guy from Texas. Team Truth. Is it possible that the lawyers for Baldoni, who are also my lawyers, I mean, listen, anything is possible. You can print out a letter now and put a December date on it, right? Unless there's like email proof, that's harder to fudge, you know? So then they go on and say the privileged communications that include Mr. Wallace but do not include Rosa Calanteri are identified as follows. Then they list it all. And they tell Judge Lyman, the engagement letter establishes that Mr. Wallace has been represented by his law firm since December 2024. Therefore, Mr. Wallace's inclusion in attorney-client communications does not, as the order indicates, destroy the attorney-client privilege. Based on the foregoing, the Wayfarer parties and the Wallace parties therefore respectfully request the court enter a protective order and or reconsider and modify its prior order to deny disclosure of the above listed documents. Defendants attempted to meet and confer with plaintiff, who indicated she opposes this motion. Duh, of course she will. Y'all, I am dying to know what are in these communications now. How about you? And now we get to the real good stuff, but this is all delicious. I am so invested. These lawyers are making so much money with every filing, every day. Tens of thousands of dollars, maybe even more. I don't even know. Like the monthly legal bills, easily in the millions. Ellen Garofalo, once again, for Team Baldoni Wayfarer, tells Judge Lyman about the Taylor Swift of it all, and in response to the high school graduate and oxygen inhalers' more modest request for time, they tell the court, quote, Dear Judge Lyman, as counsel for Wayfarer Studios LLC, Justin Baldoni, Jamie Heath, Steve Sarowitz, It Ends With Us Movie LLC, Melissa Nathan, the Agency Group LLC, and Jennifer Abel, collectively the Wayfarer parties, we write in opposition to Blake Lively's motion to modify the court's case management plan and scheduling orders. Miss Lively has not shown good cause for her proposed modification. I think she has. Y'all gave her a ton of material very late, and some of it hasn't even been produced yet. They're asking for just 10 extra days to go over everything so that they can be very prepared for their deposition. That seems sensible to me. But let's hear out the Wayfarer parties why it's not. First, they argue, Miss Lively has known about the recently produced and forthcoming documents for a month, long before she agreed to take defendants' depositions beginning on September 15th. On August 4th, 2025, Miss Lively moved to compel a further document production from the Wayfarer parties and sought several months' worth of additional communications. On August 11th, 2025, the Wayfarer parties opposed Lively's motion to compel, but indicated they would produce numerous additional documents. Following the briefing, the parties agreed to September 15th, 2025 for Steve Sarowitz's deposition, September 18th and 19th for Jamie Heath's deposition, and September 21st and 22nd for Justin Baldoni's deposition. In other words, at the time the parties agreed on deposition dates, Miss Lively knew that additional documents would be forthcoming prior to the depositions. Okay, you got me. This seems sensible also. But we know how the judge is going to rule. We know how the judge is going to rule, especially not just because he's her lapdog, Lively's lapdog, but also Judge Lyman is upset at the Wayfarer defendants for missing the deadline. He did not grant them that 1 week extension. And like they pointed out, they still haven't handed over what they need to. Oops. Second, the Wayfarer defendants continue. Miss Lively will have Mr. Sarowitz's response, non-privileged signal messages, by today. Oh, okay. Miss Lively incorrectly claims the Wayfarer parties insisted they would not produce signal communications prior to the date of Mr. Sarowitz's deposition on September 15th. The Wayfarer parties specifically told Miss Lively that Mr. Sarowitz's and Melissa Nathan's responsive, non-privileged signal messages would be produced by September 12th, 2025. Pause. I already know the response that ethically challenged Ezra and all of her other lawyers on Team Delulu are drafting. Your Honor, they say they will give this to us by today, but historically, their productions have been deficient. We cannot trust them that they will hand over everything that they need to. Dong, dong, dong. But finally, Team Baldoni Wayfarer says, Miss Lively misleadingly implies the Wayfarer parties seek a blanket 30-day extension of the discovery cutoff date. In fact, the Wayfarer parties requested an agreement solely to take the deposition of Taylor Swift during the week of October 20th through the 25th. due to Miss Swift's pre-existing professional obligations. Whether the court agrees to the broader modification sought by plaintiff, the Wayfarer parties respectfully request that the court modify the scheduling order for the sole purpose of accommodating third-party witness Taylor Swift, who has agreed to appear for deposition, but is unable to do so before October 20th, 2025. Because Blondie's got an album coming out at the beginning of October, and then possibly a lot of promo, hopefully. But misrepresenting is what they do the best. And I love that the Wayfarer parties set the record straight. So, no extension. You knew ahead of time all of this stuff. But this is why you need a judge, a good judge. You need a good judge to cut through the BS from both sides and be fair. Can Lyman do that? I told you all how I think he will rule. He'll grant the 10 days that they oppose. They just want an exception just for her. But they said, they want longer to help them and their case, which means the unliftable Blake Lively knows that what she told Taylor Swift will help Justin Baldoni. The judge needs to allow this. But I don't know. Craziness. I love it. Okay. Thoughts? Let's discuss everything in the comments section. And remember, you can get my new Grab Your Friends, Wear Your Florals merch at buypopstuff.com. That's buypopstuff.com. Also get a personalized video from me on the Cameo website at cameo.com/my name. P to the E to the R to the E to the Z to the H to the I to the L to the T to the O to the N. Also, just thank you for watching. Thank you for watching all my videos. And if you watched until now, till the end, you are a superstar member of my fam. Let's chat in the comments section. And if you want to take it a step further, hit that like button, share, and subscribe or follow if you're not doing that. I love you. I thank you. I love you. I thank you. I'll see you in the comments.